Good evening and welcome to Truth and Justice TV. My name's Dr. Jennifer Obaseki, and today we are going to be talking about immigration. Yes. So, some of you have immigration issues, and some of you are just renewing on the regular cycle. Some, most recently, we've been contacted who've missed the EU deadline. And then, as standard, we have our regular people who, for one reason or another, have overstayed. So, today I'm just going to be talking about some of those issues so that you can find out what's new and what can happen. But my first focus will be on the young people who may be between the ages of 18 and 24. If you have to renew your papers or you don't have documentation and you are in that age bracket, very important that you listen up because there has been a new Home Office concession that can affect you. Now, prior to 2012, immigration rules were such that if you were young and under the age of 18 and you've been in the UK for a long time, it was easier for you to try and regularize your status. So you've got two people or two classes of people. You have those who are born in the UK and those who might have been brought to the UK at a young age by an adult, either their parent or a caregiver. So at times, those adults have not maintained the younger person's legal right to be in the UK for one reason or another. So the Home Office had to look at people who fell in that age group. And the reason was they found that many were finishing secondary school, not able to move forward or backwards because of the fact that they did not have proper immigration documentation. This also meant many of them did not qualify for the student grants and therefore were in a limbo, either waiting for the Home Office or not able to move forward with their own personal lives. The Home Office concession looked at people in this bracket, and what they did is they decided that those people who did not then fall into the new concession, which was granted in 2012, which was if you spent half of your life here and you were over the age of 18 and 24, then you could then apply for a period of settled status. They looked at that and realized that that was not a good enough solution for so many. Reason being, people kept having to renew their status. It cost a lot of money. People ended up sometimes not being able to afford to pay for the renewal fees. And most importantly, still so many were not eligible for the student finance. There were many other cases, one in particular, which held that the failure to make sure there was a provision for young people to access student finance who were living here just because they did not have British status was a breach of their human rights. Given that judgment, which was successful by a young lady who brought the challenge through Law for All, the government decided to thankfully change the rules. And their attempt to try and rectify the situation is this new Home Office concession, which came out in 2021. And within 2021, from October, there's been a lot more information about it, who can apply, how to apply. And specifically, it again targets the 18 to 24-year-olds. But most importantly, it doesn't look at whether you spent over half of your life here lawfully. It looks at the reasons why, whether it was your fault or an adult's fault or somebody else's fault. And then it also asks you to make some submissions with regards to how you've attempted to rectify your status, also attempts that you've made to stay in touch with authorities, your conduct. And the important thing about it is it can lead to a period of you receiving indefinite leave to remain. How it does that is it looks at whether you've spent 5 years in the UK, and it looks at if you spent 5 years lawfully. The brilliant thing about it also is that it really encompasses a lot with regards to looking at the history and negating any issue of fault. So many families, for one reason or another, when they were having dependent children, so the adults, when renewing status for themselves, put themselves first, maybe as the adults in the house, and not necessarily applied for renewals for children, because it's quite an expensive process, as everybody knows. So as a result of this, there's quite a large vacuum of children, that's young persons, who in years to come may not, or may have gaps in their leave to remain, or have never been granted a period of settled status at all. So the government is also trying to sort of future-proof the next generation of young persons who may not have been born in the UK, to try and quell this problem, having a tidal wave of young persons growing into young adulthood that may not be documented and therefore stagnated because they cannot go into higher education, or they have issues with obtaining jobs due to the fact that they don't have status. So it's very important that if you are in that age group, number one, you try to get as much information about how you came into the UK as possible. And number two, that you, again, whether you're in good terms or bad terms with the adult that brought you in, just try to get a relative idea of your immigration history. That's quite important, because sometimes young persons are not told information that might even help them. So depending on when their parents have actually been granted their leave to remain, or if their parents have a certain type of status, it might actually help them. So secrets and lies sometimes lead to further and unnecessary frustration. So get as much as you can. But if you can't get too much, don't worry, don't stress, and that's not a barrier to you applying. You simply need to try and put it all together, then get some help. There are quite a few websites that give guidance, and if anybody emails into our firm, we'll be able to at least forward these on to you, so that you can see that there's quite a lot out there that can enable you help yourself if you can't afford legal fees. The next thing that you need to do is you need to decide or get that conclusion as to what exactly you will qualify for. Will you qualify for 2.5 years? That is for a renewal. Or have you had a level of lawful residence of 5 years that will enable you apply for indefinite leave? The other important thing is, if you've had any exceptional circumstances that has led to a gap or breach of your continued periods of stay, that you just make representations about that, whether it was that an adult did not renew your papers because there was no money, whether it was because you had a period where you were unsettled, homeless, moving, trauma. Make those representations and get some assistance in doing so. So once again, it's really important that you try and get some help and guidance with this. Another really key point is you can actually apply for a fee waiver for this particular concession. And that's really important, because the Home Office fees, as you know, the IHS fees, which is the fees that are charged for you using the National Health Service, are actually £1,500, which it's just a staggering amount of money. And the application fees are over £1,000. So for this particular concession, you can also try to apply for the fee waiver. And fee waivers are a really underused provision that the Home Office have granted. And during the pandemic, it's again something that people have neglected using. But one of the reasons why people don't use it is they've not really understood what is needed when making it, or not applied for it in time. The Home Office fee waiver is what you apply for if you feel you cannot afford those Home Office fees. What happens is you must go through the application form online, and then you must put within the box that you want to apply for the fee waiver and go to the separate page and fill that out. You can upload documents in support of you applying. And I always say to clients that you've got to really show financially that you cannot apply, and also evidence of any other exceptional circumstances. So income and expenditure, debts, whether you are being assisted by social services, a charity, letter from a social worker, letter from a support worker, housing officer, all these things really help. Letters from your school, educational needs officers, welfare officers within the school, really, really important. And once you put it in, the Home Office can take some time to consider the fee waiver application. So you must make the fee waiver application in good time. So that's way before you're going to renew, at least a month or so before. The reason being, you can't put your application in for renewal within more than 28 days before your leave to remain expires. So your fee waiver must be done in advance of that or at the same time at the very least, so that you try to get the two considered at the same time, and that you're not delaying renewing your application, because the last thing you want is to then fall into becoming an overstayer because you didn't have the funds to make your application. The other thing is, if it's refused, you will have to make the payment for the application fee. So what's important is that you try to look for the reserves to cover the application fee. So really important, if you're applying for the fee waiver, do so in good time, get supporting evidence, and also look for a plan B in case it is refused. The supporting evidence must be strong enough. Income and expenditure schedule, letters of support, as I've said, from social workers, welfare officers, teachers, housing officers, etc. So try your best to make sure of that. And really important, again, that you try to get those character references in as well, just to support it. But if you don't have anyone close enough to you, friends, family, colleagues, people within institutions that you've worked or schooled, then try again to make sure that you have the support as recommended by the Home Office and by some of the links that you've seen. One of the organisations that helped make this legislative change was the Islington Law Centre. They're quite renowned. Again, they are a charity, so anybody who might be minded to help support their wonderful work, please do so. And they actually received an award from the British Nigerian Law Forum this year for their very, very excellent work that they do. Going to take a short break, and when we come back after the break, I'm going to be discussing EU nationals who did not make the deadline, and also overstayers in general, what you can do to try and help yourself. So see you in a few moments. Welcome back. Thanks for staying with us on Truth and Justice TV. And today we're talking immigration, one of my favourite topics. So before the break, we were discussing the new Home Office concession. If you're between the ages of 18 and 24, the fact that you can now apply for indefinite leave to remain rather than apply for an extension. Previously, you had to do 10 years in that category by initially getting just 2.5 years, and then having to renew that 4 times before you can get your indefinite leave. Now you can get it after spending a period of 5 years in the UK. Really important you understand that you can apply for a fee waiver in that category, and also get a refund on the IHS fees if you are granted. And when making this application online, you have to click the box and put in the freestanding answer that you are applying under this concession. Quote the concession number 276 AD and make your submissions, making sure you put down how long you've been in the country, your connections to the UK, that fact that you're of good character. If you can, references from friends and family. And then if there has been periods where you've not been in the UK lawfully, or there's been a break for one reason or another, make those compassionate and submissions to outline why you have exceptional circumstances and you should be considered under the concession. If you're granted, if you've paid your fee, the IHS could be returned to you. And if you've applied for a fee waiver in advance, it should be granted insofar as you've put forward those additional submissions within the fee waiver application outlining why you cannot afford the fee and you should be granted the fee waiver. And if you need more information on it, happy to email it to you. Just contact info@obasikisolicitors.com. And going on from that, as I said, I want to talk to you EU nationals who have not applied for your period of settlement online, as you were supposed to before the deadline. So, what to do? We've had so many inquiries about this in the last 3 weeks that I thought I must mention it here. What you have to do is you have to show proof that you were actually in the United Kingdom before the 31st of December 2020, outlining that you have been here, you were exercising your treaty rights, where you were staying. How do you do that? Some people might say, try and get letters from old landlords and friends, old employers who had employed you, evidence that you were self-employed if you were, receipts, customer declarations, accountants' letters, pay your back taxes. And then you basically also have to show that you've also been back in the UK after that time. Reasons why you have not done your application in time also have to be put forward. If you were out of the country due to COVID, if you were caring for somebody, if you were not just out of the country due to COVID, and that's out of the UK due to COVID, unable to come in and do the application, but maybe you had some illness, you put this together. And the Home Office is being quite flexible on this because they've realised that there's still so many people that miss the deadline. You must do it as soon as possible. You should not be sort of still tinkering around as to what to do. At least we're trying to give you guidance, and the Home Office also has information out there that you can also tap into and get further assistance in making your application. But do not procrastinate too much longer. It may become increasingly difficult for you to sort things out if you don't do it in time. Really, really important that you give it some focus. And then generally, as I've promised, I'm going to talk about overstaying in general. Most people will know that we are been doing this for a long time now. I was calculating that the firm has been around since 2005, but I've been doing immigration law since the 1995. So for those of you that know that initially I started in North London and been dealing with immigration with regards to different types of nationals, so not just people coming out of Africa, but South Americans, Albanians, Kosovans, Afghans, and many, many more. But the point being, when it comes down to overstaying and making representations to the Home Office, again, the first thing that you need to do is try to take advice. Obviously, we all know that there's the 20-year concession that's out there. But as you've just heard, there's been changes in the legislation with regards to new concessions that the Home Office have also granted. And it's important that you also understand the threshold of evidence that you need to put forward if you're going to try and make an application. Because obviously, if you're in the country illegally, the UK will want to exercise its right to control its immigration policy and its borders. Right now, immigration is a very hot topic because of Priti Patel's quite hostile environment that she's inherited from the previous immigration ministers before her. And the hostile environment has been brewing once again since around that magic number being 2012, when the immigration laws drastically changed in the UK. So apart from the fact that you are overstaying in breach of rules and in a hostile environment, I understand that, yes, that's not very conducive for so many. So what to do about it? Start with, what is the basis of your application? Do you have a legal route to make an application? Have you been here for more than 20 years? Have you fallen into this new concession that has been granted? Are you between the ages of 18 and 24? If there's no lawful application that you can make, what are your options? So whether you have a child, maybe for somebody that's a European national or that's British, if you're caring for a British national or somebody that's a European national that's settled, whether you have a close relationship with somebody who is a European national or British and you've been dependent on that person, may all lead to you being possibly or lead to you possibly making an application. And we say may because when it comes down to how the Home Office looks at the rules, there are standards of evidence that they look for. Is it that you're presenting evidence for something that is considered frivolous, or is it something that's substantive? And when we look at that, the Home Office uses two standards. One is the subjective standard to you. So looking at your age, the characteristics of your person, whether you've got a level of network here in the UK or not, or whether an objective standard, would the average person be able to consider your evidence good enough or not? They also look at the law. The other thing that you have to think about is, what is the situation in my home country? Is it the same as it was so many years ago? What is it currently? The Home Office will look at, what were your reasons for overstaying? What have you done? Also your character. And is it safe for you to return to your home country? So really, really important that if your home country is actually unstable, that you provide sufficient evidence of that. Some people may have made applications in the past and then been refused and not taken steps to leave the United Kingdom. So as a result of that, what happens is, when you're making an application in the United Kingdom, you are considered to be here at the liberty of the Home Office because you're going through the application process. So most times you're granted a period of temporary admission into the UK. So for people who've come in and they've, for one reason or another, had to claim asylum or humanitarian leave, if your asylum application is being delayed, at least for more than a year, you may ask for certain provisions, i.e. to be allowed to work, be allowed to volunteer. Or if you're asking for humanitarian leave, again, there may be some additional provisions of support and assistance that you may also be able to seek, either through the National Asylum Support Service or through your local authority, depending on your circumstance, whether you have a level of ill health, dependence, etc. So it's really important that if you are not documented, that you try to analyse what route you are aiming for to try and resolve your situation. Are you aiming towards trying to resolve it through a legal route, which you've taken advice on and will qualify for? Are you aiming to try and regularise it through a discretionary route, which you're going to make submissions and gather evidence to support your plight? Or are you going to voluntarily return? Now, there is a voluntary return scheme. There is a level of support that can be given to you by the Home Office if you decide, you know what, I'm not able to stay for longer, I have no support, and I want to return back to my country. You have to make an application for this, and once again, we'll be happy to try and assist you with the links to the Home Office in order to make those applications, should you wish. The last thing you want to do is be detained. And obviously, once again, the last thing that you want to do is hinder your chances by putting forward any false information that may seem you as not being considered credible at a later stage when you want to make your application. So be careful what you say, make sure it's accurate. So thank you for joining me today on this immigration update. Should you need any further information, please feel free to email info@obasekisolicitors.com, and we'll be happy to send you links and give you referrals with regards to how to help your situation. So I look forward to seeing you again next week. So take care, and once again, be good, and if you can't be good, be careful.